to hear a challenge to an Illinois case. It effectively allows the high-powered weapons ban to stand.
Gun rights advocates say the ban goes too far.
Tuesday, the U.S. Supreme Court refused to hear a case that questions the legality of the ban.
A law that only affects law-abiding gun owners. These people who own these firearms, these magazines, have done nothing. If we have denied the use of these firearms, the denial of the uses of these firearms is a right denied, their Second Amendment.
I think it sends the message that the court is on the side of sensible gun regulation.
Experts that we spoke to, they expect while this case does make its way through lower courts that one day it will make its way back to the Supreme Court.
Let's take a look at the latest developments in the suppressor freedom litigation, which seeks to overturn a statewide prohibition on suppressors, challenging Illinois' suppressor ban. We're going to discuss two lawsuits that aim to remove a statewide ban on the purchase and possession of suppressors. The cases we're talking about are Morse versus Raoul and Anderson versus Raoul. These cases were filed in the state of Illinois in a federal district court, and they essentially aim to challenge Illinois' ban on the purchase and possession of suppressors. Illinois, like some other states, has bans on acquiring suppressors, and many other states also have various bans on other NFA items, like California, which essentially has an outright ban on acquiring certain NFA items such as SBRs, SBSs, and suppressors. This lawsuit in Illinois is critical because it's challenging a state ban on NFA items, in this case, a ban on the purchase and possession of suppressors. What makes this lawsuit very important is that it's one of the first in the nation to challenge a state ban. If a court rules in our favor, it would be the first time a state's outright ban on an NFA item is struck down. A suppressor ban being struck down would impact many other states with statewide bans, like California and others. Currently, in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore are not protected by the text of the Second Amendment at all. Illinois is requesting that the judge grant a judgment on the pleadings in the state's favor, dismiss the entire case, and rule in their favor. A landmark legal battle. Due to the current motion, the court has stayed all other proceedings in the case and is moving toward deciding the case on a judgment on the pleadings. The plaintiffs are trying to avoid having the case thrown out by adding additional precedents like Miller and Duncan and other cases emerging from California. Given the recent actions of the Supreme Court in various Illinois rifle ban cases, it's likely that arguments will also reference what Justice Thomas said when those cases were sent back. This lawsuit is crucial because it uses the Supreme Court's recent ruling in Bruin to challenge a state ban on the purchase and possession of suppressors. In Bruin, the Supreme Court issued an opinion authored by Justice Thomas that struck down New York's may-issue CCW licensing scheme, finding it inconsistent with this nation's history and tradition. One of the primary findings of Bruin was that the federal or state government bears the burden of demonstrating that their limitations or regulations are grounded in the history and traditions of our country. The goal of this lawsuit is to force a state, like Illinois, to explain how its complete ban on suppressors complies with both federal and current state law. In the Anderson lawsuit, the plaintiff argued that suppressors are bearable arms that millions of law-abiding citizens possess for lawful purposes. Therefore, they are neither unusual nor dangerous and cannot be banned. This is significant because it has been established that modern weapons are protected under the Second Amendment, and this protection extends beyond muskets and other arms that existed during the nation's founding. This case is not just a legal battle, it's a pivotal moment that could redefine the boundaries of the Second Amendment and impact similar bans across the country.
The Supreme Court is letting a ban stand on assault-style weapons in Illinois, at least for now. Illinois banned certain semi-automatic weapons and large-capacity magazines in the wake of the Highland Park parade shooting until it makes its way through the lower courts, skirting what would have been a blockbuster Second Amendment case. While the case now returns to lower courts, Justices Alito and Thomas indicated they would be open to taking it up down the road.
Second Amendment showdown. The Supreme Court explicitly stated in Bruin that it had already recognized in Heller at least one way the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. This makes the argument that suppressors are not protected because they didn't exist at the founding irrelevant. a point the plaintiffs emphasize in these lawsuits. The plaintiffs in both cases argue that a suppressor is neither dangerous nor unusual, and mere ownership cannot constitute possession of a dangerous and unusual item. Furthermore, just because suppressors are regulated by the NFA doesn't inherently make them dangerous and unusual. The crux of their argument is that suppressors are in common use for lawful purposes, owned by millions who use them legally. Therefore, they argue, suppressors cannot be outright banned by a state like Illinois. In response, Illinois has filed a motion for a judgment on the pleadings. The state's entire motion is based on the argument that the cases should be dismissed because suppressors are not arms protected by the text of the Second Amendment. For those unfamiliar, a motion for judgment on the pleadings is a motion under the Federal Rules of Civil Procedure, specifically a 12C motion. It's used to challenge the sufficiency of the opponent's pleadings and the viability of their underlying claims before a full trial. Essentially, it's a tactic to dismiss the entire case by arguing that the pleadings are insufficient. If a party wins such a motion, the claims are dismissed by the court, often preventing any new lawsuit of the same type from being brought forward. In these lawsuits, the state of Illinois seeks to have the suppressor lawsuit dismissed and to block any future challenges to this type of restriction. In their motion, Illinois argues that the plaintiffs have raised a Second Amendment challenge to a state law prohibiting the possession of silencers, which are attached to arms to reduce gunfire noise. However, Illinois maintains that the Second Amendment protects only the right of the people to keep and bear arms, not silencers. This legal showdown is a critical moment that could influence how the Second Amendment is interpreted in the context of modern arm accessories.
How much difference a suppressor makes in the sound of a gun.
The reason we have mufflers on our vehicles is because they're incredibly loud. That output is incredibly loud. The muffler helps dampen that noise. The suppressor is the same way. It's still very loud. I mean, action people shooting at each other with suppressor, nobody else knows what's going on. That's completely unrealistic.
Are suppressors essential arms? Illinois argues that silencers are not weapons, are not used for self-defense, and are unnecessary for the effective use of an arm. Therefore, they claim silencers are not arms within the meaning of the constitutional text, and the plaintiffs cannot prevail on their Second Amendment claim. While an instrument does not need to have existed at the time of the founding to fall within the amendment's ambit, Illinois contends that it must still fit the founding era definition of an arm. According to them, a silencer is not used to cast at or strike another, does not contain, feed, or project ammunition, and serves no intrinsic self-defense purpose. These arguments form the backbone of Illinois' rationale for why they can completely ban these items. Illinois further argues that while some people find silencers useful, they are not so critical to arm ownership that arms cannot be used effectively without them. This is an interesting point, not just in this Illinois case, but in many others, where the argument is made that banning one item is acceptable because it is not imperative for self-defense. For instance, in the famous Heller case, D.C. argued that while individuals might not have access to handguns, they still had access to rifles for self-defense, implying that handguns were not crucial for self-defense. Thus, they suggested banning them was unreasonable. This debate over the necessity and definition of silencers as arms is at the heart of the legal battle, reflecting a broader struggle over how the Second Amendment is applied to modern arm accessories.
When an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed.
Moments ago, again, the restraining order against them should have access to a gun.
The year before I came to the presidency, the murder rate was the highest increase on record. Those rates are continuing to fall faster than ever. Last year.
Upcoming hearing. Illinois is making a similar argument with suppressors, claiming that arms can still be used for self-defense without them, and therefore they can ban silencers. There are two interesting points to note here. First, Illinois completely avoids and disregards all the federal laws that regulate suppressors under the NFA, treating them as actual arms. Federally, these are regulated as arms, but Illinois ignores that fact. Second, they gloss over the fact that the Second Amendment does not only protect projectiles or weapons that shoot projectiles, it covers people's conduct and critical activities. It also protects other types of arms, like body armor and helmets. anything someone could use for self-defense and other protective purposes. What's particularly interesting about this case is that it's moving toward a judgment on the pleadings. This is stalled for a bit because many of the arguments in the suppressor case in Illinois are tied to the rifle ban arguments challenging the Protect Illinois Communities Act. This lawsuit is connected in some ways to that. Recently, all the Illinois rifle ban cases were denied review by the Supreme Court in an 8-1 order and sent back down. Only Justice Alito would have granted review to those rifle and mag ban cases. However, Justice Thomas issued a statement agreeing that the issue of rifle and mag bans statewide, like in Illinois, is critical and needs Supreme Court review. They just want a final merit decision. Now that those cases have been sent back to the lower court, Judge McGlynn is moving those rifle and mag ban cases toward a final review. As a result, the Illinois suppressor case is also moving forward again. The court has scheduled a hearing for August 21st of this year. This conference will discuss the progress of the case, how it will proceed, and possibly when it will proceed to a full hearing. So that's the latest on the suppressor lawsuit in Illinois, an unfolding legal battle that could significantly impact Second Amendment interpretations and arm regulations.
Purchasing a suppressor for your firearm is not a speedy process. It can take months, and it also comes with a $200 tax stamp. They say the resolution will make it easier for gun owners to get their hands on a suppressor and protect their hearing. Now that's on top of having to wait up to 270 days just to get the paperwork.
Have been used to murder police officers, and I think in this case we're putting profit above safety.
This simply reduces the noise so it does not cause potential damage to your hearing, but it's not a silencer, it's a suppressor.
Saying easier access to suppressors would be more beneficial for criminals.
More accessibility to silencers will downplay the power that guns have.
That's all for this video, folks. We'll see you next time.